do first is I'll take up the motion to disqualify our firm. As I read the petition to disqualify us, I start with this observation that the burden is on Mr. Gill to establish that disqualification is mandated. It is his burden. He has failed to do so. And while citing a number of rules, which seems to be cut and paste of the rules of professional conduct, the only truly applicable rule is 1.9, which has to do with former clients. The thrust of Mr. Gill's motion to disqualify is that Shaheen Gordon is disqualified because Mr. Gill made statements, false statements, in fact, accusing the firm, Bill Shaheen, Senator Shaheen, along with a host of other law firms and public officials of criminal conduct. Because he made these false statements accusing the firm of engaging in criminal conduct, it is his position that we have an interest in the litigation and thus should be disqualified. That proposition is simply preposterous. He cannot exercise a disqualification motion on the premise that he's made false statements.
I do have a question. Did I understand, though, that Shaheen and Gordon represented either the mortgage specialist or Mr. Gill in the past in some other
Yes.
manner? Okay. I mean, he's really made two arguments here. One is because of the issue you just raised, and the other is because of the prior representation.
He made an allusion to it, that we had done prior work, but he has cited no cases that we worked on. He cited in his motion no particular matter, and the driving issue in disqualification under Rule 1.9 is that it is the same or substantially similar to prior representation. The prior representation was 7 years ago, was the last bit of work that was done. It started in approximately 2005, and the last bit of work was sometime in around 2009. There's been no work since that period of time over the past 7 years. There is not one single case that was worked on for Mr. Gill that has any bearing to what this defamation case is. So the first question that the court needs to ask, is this action the same or substantially related to any prior action in which the firm represented Mr. Gill? And the answer is clearly no. First, he hasn't cited any prior representation that is at issue that we worked on that could even have the closest bearing to a defamation per se action. And that burden is on him, and therefore he has failed in that regard. Second, the case law that we set forth in our pleadings make it clear that time attenuates conflicts. Cases that we cited in our memorandum show that prior representation 7 years in the distant past is not the basis for disqualification, even when the matters are closely related. The matters that were done for Mr. Gill had to do with a range of issues related to some regulatory matters, matters related to permits, etc. Nothing having to do with civil litigation pertaining to a motion related to anything with defamation. Second of all,
I'm sorry, I only heard half of what you said. It had to do with permits and what other issues?
there were permits, there were some issues before the Banking Commission. There was litigation involving mortgage specialist versus Davey, which actually went to the Supreme Court. We were not counsel of record in that case. There were some small employment matters that were involved. There was litigation in the First Circuit having to do with trade secrets, I believe. There was litigation in Boston, Massachusetts, having to do with signs that were located at Suffolk Down. So it was all commercially based litigation that was done with a tad of employment in there. The last bit of work that was done was, in the last billing, was in June of 2009. Any further questions on that? So none of that prior representation has any bearing whatsoever. So under the test in our Supreme Court as to whether or not it's the same or substantially similar, there's been an abject failure to do so. I'm prepared to move on unless the court has any other questions. And the one thing I should add is that in Mr. Gill's divorce proceedings that we've attached to our pleadings, there are numerous court orders that discuss his finances, that's made public, how much money he's earning, where he's spending his money. So there is no claim and can be no claim that somehow we have personal financial information from 7 years ago that is at all relevant to this proceeding here today.
I just have a follow-up question to that, which is, I think Mr. Gill makes an argument as well that there may have been information, confidential communications between the firm and Mr. Gill that may be used, or that could potentially be used, down the road if there are evidentiary hearings and Mr. Gill has to testify. I don't know what the nature of those communications are precisely, but that it's at least conceivable that he's disclosed information to the firm that could be used to impeach him or otherwise attack his credibility in some way. How does the court address that?
The court addresses that in the construct that the case law suggests that you have to make a direct showing as to what that information is. And
disclosing the confidential?
No, but what would it be? What is the communication that he disclosed, or the information that we have? We have none. I can represent to the court. This case is a very simple, straightforward case. It's whether or not there's defamation per se, whether the statements are true or not true, and that is a straightforward matter for adjudication. He has the burden of, we're denying the allegations. He's going to be demonstrating what evidence he has to prove his case, and that is how the case is going. There is no information that I know of that we possess that would at all become relevant at all in any of these proceedings. If that was the case, anytime you had a prior representation of a client and there was some disclosure of confidential communications, that a lawyer would forever be barred from suing that client in a matter that has no bearing, no substantial relationship, due solely arising out of the prior representation. Furthermore, I would also represent to the court that if, I can't imagine that it would ever happen, but that we would not at all use any prior communications with Mr. Gill at all. There's likelihood that some of these files have even been destroyed because they're over 10 years of age. Can I?
Yes.
Your Honor, we're keeping the 15 minutes?
I am, yes.
I just want to
20, yes, 20 minutes, 15 for each.
What I'd like to do is go to the extrajudicial statements.
Okay.
We have a video, and maybe, because I don't have all that much time, maybe what I will do is just start playing some of these statements, and we'll fast forward through, just so the court will get a flavor of Mr. Gill's misconduct here. Bear in mind that Judge Smuckler issued an order denying our motion to bar extrajudicial statements, but also at that time put Mr. Gill on notice that any statements he made post Judge Smuckler's order would be considered at this hearing. Our tape here is about 18 minutes of Mr. Gill's.
18 minutes, Your Honor. He's already been at 12.
I like the 10 seconds of interruption. We're going to cut it short, but what we're going to do is give you a flavor of his post-judicial comments that actually continue to abuse our clients, made false statements, abused said that any judge who entered an order in this case, banning him from making extrajudicial statements would be corrupt, that the system is corrupt, and that our clients put in judges who are corrupt in order to protect themselves. Mr. Gill.
Your Honor, I'd like to object on one thing. It's like if he's showing you sampling. I know if you're going to form an opinion.
Mr. Gill, you can address those arguments. I mean, you're cutting into your time, so you can address those arguments. And
I'm just saying he's taking pieces.
I understand.
All right.
You're using your time, so you can.
So 10 seconds.
And accused Mark Howard, and he was a defense attorney at FRM, protecting and working with Gonzalez. Well, guess who became the judge on the case? Him. What did he think? Did he forget that we might have a conflict? You know, like a few 100,000 conflicts? This is the move of desperation. They're desperate now. They're obvious. Certain people don't want to touch. Let's go back to Judge Francois. He put an order in to destroy the tape. The same tape that would have shown him refusing critical evidence of the corruption of the case, Walker, the evidence that they destroyed, and even threatening my children. He's out there, no, I'm not taking it. It says it right here.
Well,
They would like a permanent injunctive relief consistent with these accusations. Meaning, all right? Media, you're at fault because you built up these monsters. Right? You made them citizen of the year. You're covering your own bacon, but they have that level of danger. This is what you've got to remember. You've got to remember the logic in this. You got to remember what has been done. You've all been conned. The media have built up these people. They've taken their drug money and invested it. What did I say, the Banking Commission, about drug laundering? That's quite negative. In fact, Andos, Cruz, and Griner has recently been on the sign. Shaheen's been on the sign in my videos for the last few years. Right, because I caught. Is the media want to see some evidence?
This is after court hearing, Your Honor.
Who's the media? You're the media? Would you like to see some evidence? Of the actual.
That's a reporter from
The news. They have.
If we're in the news, I can take your contact information.
Okay. Would you like to see it for a second?
Well, I have to look for something else right now.
So you don't have evidence? What is it with reporters who don't have evidence?
If there's something else that I have to do, then we'll take a look.
So, Your Honor, what I have here is I have actually the full, which I'll introduce, the full video.
This, do the defendants have a
Yeah.
copy of that?
When you review that, you'll see a whole series of postings that Mr. Gill made, where he talked about evidence in the case, machine guns, and they need multiple witnesses to come forward, but these witnesses are fearful for their safety, that the lawyers are involved in the cover-up, that he put on the tape on April 29th, that he's winning this case because people are coming forward with evidence showing corruption, our clients engaged in drug trafficking. On May 3, he says at a press conference, when asked after a court hearing, he went outside in the lobby, conducted a press conference going over the evidence in the case that he believes he has. A question was asked, are you alleging these men are selling drugs now? Was the question asked at a press conference. He says, yes. Why do these people come to you with all this evidence? Mr. Gill says, because the system is corrupt. Why don't witnesses go on your show? Because they are afraid for their lives.
ask about those statements? I mean, the rule, I granted, doesn't directly apply to Mr. Gill because he's not an attorney, but attorneys under Rule 3.6 are allowed to make comments that are based on information that's already a matter of record in the court. I mean, it sounds like what you're describing for me is what he's alleged in his complaint in this case. So how would that even violate Rule 3.6?
He's talking about evidence in the case that he doesn't possess. He has a.
I object, Your Honor.
Okay.
I do possess that evidence.
But he's filed a verified complaint alleging that he has that information. Whether it exists or not, the discovery in the trial process will determine, but.
I don't think he's filed a verified. He's filed an answer that his statements are true.
Oh, I'm sorry, right, okay.
Yeah,
Yes. I understand.
That's what he's done. And I think that the rule is that lawyers are not to bring up information that could substantially impact a fair trial. And lawyers are also very
Well, I'm not a
cautious.
lawyer, Your Honor.
Well, Mr. Gill, Mr. Gill, courtesy, you've interrupted now several times. They have still at least 4 or 5 minutes by my calculation.
So that's 20 right now.
And the more you talk, the more it's getting into your time.
So if a lawyer knows that certain evidence is not admissible at a proceeding, lawyer cannot say, I have this evidence that the lawyer knows is not admissible. If a lawyer goes and tries to poison the jury pool by going out, and he's a litigant, and there's case law on what litigants can do. The basic rule is that litigants cannot engage in conduct, whether it's under our rule that applies to lawyers, that has a substantial likelihood of impacting a fair trial. That is the general rule. And by Mr. Gill's statements and the parade of these statements that you will see, his very purpose is to inflame, to prejudice, to interfere with the administration of justice, just by the very nature of his statements.
Well, so, again, I'm using 3.6 because it's the rule that's designed to address the concerns that you're raising
Right.
on your motion. And 3.6C says that notwithstanding the general rule that a lawyer can't make statements that might prejudice the adjudication of a proceeding, it has several safe havens, which include a lawyer can state the claim, offense, defense involved, and except where prohibited by law, the persons involved, information contained in a public record, investigation is ongoing, the scheduling steps in litigation. I mean, some of what I heard here at least involved different things that have happened in the litigation. So I guess why doesn't that fall within the safe haven of 3.6C?
The reason is, one, he can say what his defense is. The defense is truth. He can say something that's in the public record. He has not said anything that's in the public record. What he has done is he has cited himself as the public record and then uses what he cites as his own authority for being his evidence. Saying that judges are corrupt, saying that our clients have bought judges, saying that our clients have placed judges in because they're protecting themselves, saying that we're engaged in selling drugs, machine guns, that we're killing children. There's no evidence for that. That is not a defense. And in order to make those statements, there needs to be, if he wants to file a pleading with his so-called evidence, then that is something that he may be entitled to do. But what he cannot do is he cannot undermine the administration of justice, poison the jury pool by saying, I have all this undisclosed evidence, I have all this undisclosed information, it's the truth, and I'm prepared to show it, and then go forward with his litany of horrors and falsehoods. That is what he cannot do. That is what a lawyer cannot do. That is what a litigant cannot do. And the case law, particularly the U.S. versus Brown case, that we've cited and a host of other cases that we've cited says that a litigant to a proceeding cannot undermine the administration of justice by holding press conferences and undermining that process. That's my 5 minutes.
Your Honor, this will take me about 90 seconds to address the motion for attachment issues.
You have exactly 90 seconds.
Okay, first, the motion to attach with respect to Mr. Day is withdrawn without prejudice. This is a supplemental filing that contains a compact disc that cites to the allegations in paragraph 29A through M, which not only contain the defamatory statements but show the context in which they were made. The 3 sets of facts, Your Honor, that are relevant to the attachment issues. First are the substance of the statements that are discrete. They're outlined in paragraph 29, A through M. Second, without admitting that my clients are certainly public officials or limited public officials, that's a standard Mr. Gill has to show. If you were to move to the next step, the relevant facts that describe actual malice, which is knowing falsehood or reckless disregard for the truth, the context of those facts are the greater context of which these statements were made, which is basically everybody in the state is corrupt, from the Manchester Police to the State Police to the Attorney General's office to the Assistant U.S. Attorney's office to the judicial system, and because everybody else is corrupt, Mr. Gill is the only person that can be trusted, which is, of course,
I object, Your Honor, I've never used
the
the word at all.
last bit, Your Honor, which is relevant, is a similar sounding word, but it's common law malice, which is enhances damages. When this motion was originally filed as ex parte, Judge Smuckler denied it for lack of damages. That is why we submitted a motion to attach with notice. It has additional pages. It shows about 6 to 10 million times these statements have been published. It shows the context they've been published, and it gives you some instructive case law to make a determination of damages from, Your Honor. Ultimately, if the amount I'm seeking is not satisfactory, you can find that.
Actually, I'll hear from Mr. Day first, and I'll let you go, Mr. Day.
Well, I'll be relatively brief on it, so I just want to address, Mr. Day has been brought into this lawsuit. In fact, the whole video that we have here, what you've seen, has nothing to do with Mr. Day. And the only position that I have with respect to this extrajudicial statement is as follows. Mr. Day, this motion is essentially premature with respect to Mr. Day. You haven't heard anything with respect to Mr. Day making extrajudicial statements about this case or any case. And I'm sure, Your Honor, if those existed, you'd see him in front of you. Okay? My client's not an attorney. I'm the attorney in this particular case, Your Honor. I most certainly have no intention about violating these rules if in fact they even apply in the setting that we're talking about here. But, I mean, the order that's my concern with respect to the proposed order that's being issued or is arguably issued is overrun my client, Mr. Day. He's actually running for U.S. Senate. Your Honor. And in this case, and all these gentlemen are all heavily involved in politics, it's my understanding, Your Honor. I'm very concerned about what this proposal or the proposed order has to say. I mean, when you look at their argument, it talks about, on the first page, during the pendency of this proceeding without prior court order, defendants involving Mr. Day shall not make any statements that are published in any medium, including but not limited to Facebook, goes on, that comments directly or by implication on the character, credibility, and reputation of the defendants in this case. Your Honor, this is clearly overbroad, unduly burdensome, and really isn't even necessary with respect to my client at all. And so with respect to my client, okay, and I'm not going to take a position on it, but with respect to my client, this order should not enter as to my client at all. There's been absolutely no evidence at all, or even a presentation put on at all, as to how Mr. Day has done any of these things. With respect to the other motion, my understanding, the motion for the attachment was withdrawn as represented. I've got no personal.
You did also file a motion, though, to bifurcate or sever this case, did you not?
Well, I did, Your Honor. I don't know if there's been some discussion, apparently there is gonna be, or there may be, an amended, a motion, an amended complaint filed as to my client, Mr. Day. At this point, I guess, if that's what's gonna happen, you know, I would withdraw the motion without prejudice at this point, and we'll deal with that issue when it comes to play. I don't wanna have to go down that road twice, Your Honor.
Okay, thank you. Mr. Gill?
Hello, Your Honor.
Good morning.
All right, can we start by the recusing of Shaheen and Gordon? Mr. Gordon kind of breezed over the cases. Turns out they represented me for approximately 9 years. And when that representation ended, is when I caught them extorting me for $100,000. That's the reason why. So let's just look at the cases. Mr. Gordon said, in his own words, an array of cases. Well, let's look at the cases that they were on. How about the IRS? He forgot to mention that. It's still outstanding and I'm still being leveraged through corruption. And yes, I do believe there's judges that are corrupt, law enforcement is corrupt. I didn't say all, but I believe that they are. The DRA, he forgot to mention the DRA, they were part of that too. And I'm still being leveraged by that. Division of banks. Right, 3 bogus consent orders that they did draw back for my silence. I want to tell you, Your Honor, I've refused multiple offers for a settlement that would include my silence in all these matters prior to this. Right, $50 million, by the way. This extortion, for instance, they forgot to mention the signs. This extortion came from the signs. Was $100,000, which is why I put Bill Shaheen on there. But Shaheen and Gordon, I also filed complaints with the Department of Justice against Shaheen and Gordon, against these individuals that they are well aware of.
So, how is, I guess what I'm not entirely clear on from your perspective is, how is all of the representations you're talking about related or substantially related to the defamation claims that the plaintiffs have asserted against you in this case?
I'll get on to the defamation claims because I have evidence and proof. But as far as the recusal, they've been working together. In fact, Your Honor, I have evidence that I brought, a couple of pieces that suggest that they've been working criminally together, Shaheen and Haganos. Now I will turn this into evidence that you can see this. Now what also I'll say,
Do you want to submit something?
we can submit those.
Well, now's your time since we're at the.
All right, but listen,
Make sure
I'll
tomorrow.
explain, for instance, the recusal. Now, ready? The signs. They extorted me for $100,000. I have a check that says that fact, that they had the city cash and the city manager said they got it. So in other words, there is corruption, and these are the people who protect the corrupt. See, this is how it works. Are we supposed to ignore the fact that Bill Shaheen's wife is the senator, and that he's not running Hillary's campaign in the state of New Hampshire? I mean, this is the political protection that we're saying here. I had no motivation to bring this forward. I didn't know the plaintiffs, but I did get the evidence. And what you're seeing in me bringing that forward, everything you said that I stand by as being the truth. And I'm getting more and more evidence. So as far as the recusal, they all represented my controller, Lisa Tracy. They leveraged her with her 3 daughters in a molestation case to destroy and extort evidence from me. This is a fact. I've been dealing with this for 5 years on the sign, and they show up. So if they can shut me down, they're improving their own situations and protecting criminals. Okay, so in other words, know this, a variety of cases. They've been on the sign before they were. Now let's get to the plaintiffs. What you've seen in there was me talking to a union leader reporter with a case number that I got from the arresting state police officer, James Keenan. He turned around and told me about a roadblock on Hooksett on the highway. He told me about Silly Street, Weston Avenue, Aganos's properties, where they arrested him, drugs on the property, money on the property. They went to his bank. They got cold bars. Now, you ready? They want to turn around and say, well, that account number doesn't exist, except for we turned around and did a 91A to the State Police Narcotics Department on 2 different occasions and got a response that said that they had and found the file. Okay? So that is a matter of fact, what I'm saying. Now, what I'm going to ask this court in a form of discovery is from here, I'm going to the U.S. Attorney's Office and the DEA, which is why I wanted to be here from the beginning, with 4 witnesses that are going to require protection. Now, I have other ones, like the state trooper and the arresting officers. Now, we have that. But I want to bring them forward. You're going to find out that they've been dealing fentanyl. I'm going to tell you how they got it. I'm going to tell you how they move it. Right? I'm going to give you those people. So in other words, this is why I've come here. This is why I've come forward. There's no motivation other than doing what's right. And I do believe there's corruption. And I believe there's been corruption in this courthouse that I'm willing to prove. And one of the witnesses I have against Shaheen was one of the own attorneys that were working for them. Now, I'm saying this as evidence, and I am swearing under oath that I have those people, and they are with the Department of Justice, and there is a grand jury going on that will verify what I said. You heard them say about the Banking Commission, I stand exactly by that. And what I'm going to do is file that protection, go to the U.S. Attorney, which I have reservations, but into the DEA. They will have these witnesses. They are prepared to come forwards. They will talk to you about machine guns and moving drugs. They will even talk to you about the distribution. They will talk to you about the prices and how they get it from New York and comes into Lawrence, Massachusetts. They will talk to you about how it comes from Boston and how they deliver it here. They'll talk to you about motorcycles. They'll talk to you about a relationship of one of those motorcycle people that went to the police and they were turned around and stopped. But they'll tell you they witnessed machine guns and they'll tell you they witnessed heroin. So in other words, I am in complete confidence. What they're trying to do by shut this down, quiet. Listen, when we were in the first hearing, there was more cameras and press than people. So I'm talking to show innocence afterwards?
Can I just bring you back for a moment to the disqualification of the law firm Shaheen and Gordon? Can you, I'm still trying to understand how, I know they represented you, it sounds like, for a long time on a number of different matters. I'm still trying to understand how, from your perspective, that creates a conflict in this.
They know every weakness that I have. They know issues with banking. They know issues with the IRS. They were involved with them. Those pieces and pieces are being leveraged now. This is part of the leverage plan. This is part of the orchestration of that leverage, and for my silence. Right? So it is absolutely related. They are amongst Alex Walker and Shaheen and Gordon and McLean are the principals to this, which is why they show up now. Listen, Bill Shaheen comes and he goes. Is he on the case? Did he file an appearance or didn't he? Or is it just for show? You see? That's what we deal with. And what I'm telling you, I'm getting more and more evidence. It's an avalanche of evidence. There's no question about this. And I'm telling you, there's a grand jury going on in this state right now, off of everything that I'm saying now. And I'd like to think that I had something to do with it. Okay, Your Honor.
Anything further? So I will take these issues under advisement and issue a written order on all of the outstanding motions. Thank you. All right.
We can just go into one of those side rooms. There's a couple.
Get your father.
That's occupied. My apologies. There you go. Get them all.
The rules of this work. For someone that's new to covering all of this, explain.
Could you talk a little louder? I'm sorry.
Oh.
I'm a little deaf.
Can you explain what just happened in there in your own words?
Well, what's happening is it's a cover-up. Shaheen and Gordon knows who Agonos, Cruz, and Griner is. They do business together. If you get them, you just might get Shaheen. If you don't believe there's corruption in this state and it's being protected in the courts, I mean, we only have the worst heroin problem in the United States per capita. How do you think we got that? Listen, I have evidence. I have 4 witnesses that I'm going to the U.S. Attorney and the Department, DEA. Now, they know I have this. I'm going to give them the witnesses. I'm going to give them the names. They're all current witnesses. And we're going to let the Department of Justice do it. And how's this? There's a secret grand jury going on right now. Asked a few questions.
How do you know that it's secret, Mike?
Yeah, if it's secret, how do you know? I mean,
Well, if it's secret, do you think more than one person knows about it? Do you think maybe the fact that I know about it is I've been turning evidence over to them now? Maybe that's how.
You didn't introduce any evidence.
Maybe that's how I did produce evidence. In fact, what they were trying to show you in there was I was talking to a union leader, reporter, that I was showing him the evidence to take pictures of, except for it didn't make the paper. See, the problem I have is that these people are paying the bills. Who's the biggest advertiser in Channel 9? Who's the biggest advertiser? A union leader. Maybe it's just those plaintiffs. That's what I'm dealing with.
did you introduce any evidence today?
I prepared to do this. In fact, I have the evidence. I asked the judge, and the judge, what I'm going to do is I'm going to give it to the judge. I'm going to inform the judge today that it's going through the United States Attorney's Office so that these people are protected. So we can bring these witnesses in, which is what I wanted to do.
And what are you saying that these witnesses will show?
Oh, how about one witness who's only best friends with the son, who's only working in the motorcycle gang, who put it down in writing that they're picking up the fentanyl in Boston. The father is picking it up in New York. Max is picking it up in Boston. They distribute it out of Lawrence. Have you noticed all the arrests coming out of Lawrence? They're moving it back. Why do you look like that?
No, I'm trying to understand.
Because-
It's a lot of information.
Well, it's not. Just look what keeps happening. There's not multiple arrests each time in Lawrence. Motorcycle gangs. In fact, the guy, Kenneth, the state trooper, he was in charge of motorcycle gangs and corruption and narcotics. How do you think they got him?
Shaheen and Gordon are now representing the gentlemen that are bringing
Right.
the suit against you. Are you trying to get them off the case? Is that what this is about?
I'm trying to show who they are. If this is corruption, they stay on the case. It shows the corruption that we are talking. They were only my attorneys 9 years. If you've noticed, for the past 5 years, they've been up on the sign. I have a $100,000 extortion check. I've got it still. So does the Department of Justice. I'd like to think the secret grand jury has to do a lot with that. Have you noticed with the Banking Commission too? The Banking Commission resigned. Did you know there's an investigation? And you know who's investigating them? The DEA. You know what for? Money laundering. Now how's that? You know what one of the places they're investigating? Primary Bank. For money laundering.
Mike, there's just no proof of that.
Yes, there is proof
And
of
I'm from the
that.
media, I'll take the evidence and I'll put you on
How
the
do you
air.
know there's no proof?
I'm asking for it. I'm asking
You're asking
the
for it.
proof.
I'll tell you what.
Unlike the union leader,
I'm going
I'll
to
put
give
you-
it to the Department of Justice.
I'll put you on the air.
Hey, look,
I will put you on the air. Bring the
I will put
evidence.
it to, how about this?
Bring the
We will
evidence.
put it
Why
to-
do you seem so angry all the time?
Angry?
Every
I've
time
had-
you lose a court case, it's corruption.
First of
What's
all,
going on? What's going on?
First of all, there is corruption in this state. Are you telling me there's no corruption? Is that what you say? Go on, say it.
I can't speak to it.
Oh, well, wait a minute, you can't speak to it,
Mr. Gill, could I have-
so you can't say
Maybe
there
now,
isn't
please.
corruption. You just can't speak to it.
I'm just
Well,
not-
how about
I'm
this?
just not gonna
I
say
can
it.
speak to it, and I have evidence, and you're
I'll
right
give you-
behind the
I'll-
U.S. Attorney. You understand?
I'll
You're
give
not
you
gonna
a
protect
forum
these
for the
witnesses.
evidence. I'll give you a forum for the evidence.
Good. Well, then, you
Gentlemen,
know,
that's enough.
I'll give you the
Yeah,
forum for the
and what
evidence.
form is that?
That's what you have
Where do
court for.
Where do you work on?
iHeartMedia, AM 610.
Hey, listen, I'm all about going out to the media. Have I ever refused an interview?
I'm
I
asking
ever
now.
approved not talking?
I'm asking now for the
How about
evidence.
this? I'm going to put the evidence here. Listen, I just put it there. I have it. And if you look at Facebook, you're going to see some of these people yourself. But I'm going to make sure that they have protection. And then you know what I promised? I promised to go on your radio and anybody else's radio station they want me on. How's that? Oh, I have evidence, brother. How do you, what do you bring? First of all, I've been bringing out. I only gave them a case number. Now listen.
Mike, I would like to get, listen,
All right,
I'm
all right.
I'm willing to put you
Take
on.
this information. I will give you the case number, the fact that the two people inside, the state troopers, narcotic division, found the case. Two. So now if they found the case, would you believe it exists?
If you give me the evidence, I'll
Okay,
give you
you
the
send him
forum.
the,
I will give you the forum.
Lauren, get his information. Say your information out. Mailing it.
My card, I don't have to
Give
say
me
it.
your
Give me my
card. You're gonna get it, all right? And you're gonna put it on. So
won't.
you're going
You
to
won't
see
have
it.
a forum.
So do you believe there's a case? Do you believe he's been arrested?
I don't know that there's a case yet. I haven't
There
seen
you go.
any- I haven't
Well, you're
seen
gonna
any.
know that there's a case.
I know there's not a case.
You know?
I know.
Well, who are you?
It doesn't matter, for you to come forward, you must be on solid foundation.
Solid.
You have no stones in your own life.
None. Come and get it. How about this? 8 years, 10 years fighting these guys. If they had some, they'd be on it. Why do you think I go after these guys like this? They can be all on it. You don't want to say your name, huh? Good. Well, it does matter if you have an opinion. So yes, I am on
I have
solid
an
ground.
opinion, I have facts. There's a difference between opinion and fact. You have opinions.
I have evidence. I'm going to show you not only a case number, I'm going to show that they retrieved the case. You know what the case? Drug smuggling. It was even a case of rape. How's that? No, it all exists. Hey, why don't you call the state trooper? He lives in Hudson, New Hampshire. His name is Keenan. He's in the book. Pull it up. All right. You think that's funny, huh? I'm telling you they don't. We'll just watch people die and do anything.
Well, I won't back down. No, I won't back down. You can stay.